Good morning, everyone. My name is Edwin Grieve, and I'm the Director for Area C in the Comox Valley Regional District. And as I was the Vice Chair for 2022, I'm serving as a presiding member for this meeting that will probably have its inaugural meeting in January, at which point we will elect a proper chair. But in the meantime, you're stuck with me. I'm going to call this meeting to order of the Electoral Area Services Committee for Monday, December 5th, 2022. I would like to welcome the gallery and to just point out a few things. We have, in case of emergency, we have exits where you came in. We have exits on the side doors as well. And any case of if we're experiencing some kind of emergency like a fire, that the muster point will be outside in the parking lot. Also, the comfort stations are in the back around here. There's 2 washrooms available. Actually, there's only 1 washroom available right now. The other one's under more reconstruction. That being said, I would like to welcome you here, and I'd also like to take this opportunity to welcome my fellow directors. New this year in this term, we have Director Richard Hardy representing Area B. Welcome, Richard. And once again, from Area A, we're lucky to have Director Arbor. So we're going to go through the meeting here. We have, first of all, recognition of traditional territories. We are doing our business today on the traditional unceded territory of our Comox First Nations. Management report is our number 1 on the agenda, so I will entertain a motion to receive the management report. Second. Is there any discussion on the management report? Seeing none, I'll ask for a vote. All in favor? That carries. And the second on the committee, we have land use planning legal orientation. Louis Carvello from Carvello Law is here to provide information regarding planning and development. I'm sorry? Back up a little bit here. I'm sorry. Getting ahead of myself. We have number 1, the Electoral Area Services Committee terms of reference for receipt. Move a second on receipt. Now, is there any discussion on terms of reference? We do. Director Arbor.
Yeah, thank you. A question to staff. Something that came up in orientation at the board was around the authority of the various committees. And I think what was briefly discussed was whether this was an opportunity for ESC to have more delegated authority from the CVRD board. I see that under the terms of reference, our authority, it says the ESC serves as an advisory body to the CVRD board. And so I think when you think about the role that this committee plays in regards to the rural areas, and also from some of the municipal answers or comments at the time, that we send a lot of our staff up to the board. I'm wondering if staff sees an opportunity to at least understand if there could be an opportunity to lighten the load of the board and keep more of our decisions at this table.
Mr. CEO.
Yes, thank you very much, Chair and Director. And if it is the desire of the electoral area directors to explore delegation and what greater authority they can have in terms of decision making, by all means, staff can prepare a report and outline to you what the opportunities are there. That was sort of the conversation at the board. We have other issues, other services, sewage commission, and otherwise that operate under that. So a resolution of this committee to direct staff to prepare a report, and we can bring back for you some options or considerations to give. Those would subsequently go to the board for them to delegate that authority if that is your desire.
So we can bring that up under new business, Director. Thank you. So that's a very good point, because I have heard from our municipal colleagues that they basically start nodding off when it gets to the electoral area session of the board meetings. So, okay, so I guess we're on receipt. I'll take a vote on receipt. All in favor? That carries. Now I'm going to do this properly and turn this over to our CAO for proper introductions of Louis.
Thank you very much, Chair and Directors. And yes, Louis Carvalho comes north from Victoria, where the grass is still green, I believe. And thank you for braving the weather. Louis has a degree in both urban planning and environmental studies. He is both a planner and a lawyer. He's worked with developers both at a pre-law development consultant and while at McCarthy Tétrault, one of Canada's largest law firms. He's worked in municipal and regional governments in Ontario, England, and BC. Louis spent 6.5 years with a boutique municipal law firm working with local governments across the province before establishing Carvello Law in 2010 to focus on his professional passion, planning, development, and environmental law. Carvello Law has grown from the original 6 clients to serve 55 or more local governments across the province, in addition to other public interest and bodies such as non-profit conservation organizations, improvement districts, and the provincial government and First Nations. So I welcome to you Louis Carvello, who will provide you with some background with respect to the law around the decisions that you make with respect to planning, development, and bylaw.
Welcome, Louis. And when you press your button, I can turn you on. There we go. Thank you.
Thank you, Chair, and thank you for the introduction, Mr. Dyson. I come to you today to first begin by telling you the phenomenal amount of power you have in terms of planning and land use management in the regional district, in particular the electoral areas, because the municipalities have the planning powers within their own municipalities. And that's a product of the legislation that we have, that's the province has given local governments that amount of power. And I point to 2 different examples of this. First of all, the breadth of the power. So when it comes to land use, density, siting size, dimensions, those are typical zoning powers. We have, if you're interested in dealing with the environment, we have an array of powers related to that, including development permits, dealing with conditions for hazardous lands. There's floodplain regulation under 524 of the Local Government Act. There's the development permit power as well, which is protection of development from hazardous conditions. There's something as simple as a landscaping and screening authority, which is separate from the zoning power and separate from these other powers in terms of establishing requirements and regulations for landscaping and screening that can be used not only to separate uses, which is what it normally does. You know, the typical use of that authority is to separate industrial uses from residential uses with some sort of barriers. But it can be also used to enhance the environment. So it's not just about regulation in terms of prohibiting, it's about enhancing the communities that you live and work in. So as a not the best title, we refer to that as the planner's toolbox of tools. You can regulate to the point of determining the maximum amount of impermeable surface that will be permitted on a property. With respect to storm drainage, with respect to form and character of how things look and feel, right down to colors and types of materials that are used. So you can see that the Local Government Act has delegated quite a significant amount of authority to local governments to touch how land is developed or not developed, as the case may be. And those are the decisions that are made at the local level. The other example I use as to the breadth of the power that you're dealing with is just when it comes down to zoning, using zoning as an example, that has been recognized by the courts as being inherently discriminatory and discretionary. So now discriminatory is on a property level. The ability to say one property is a commercial property and another property is a residential property or industrial, whatever the categories are. The ability to make that discrimination on that use level as between properties. So we're always careful not to talk about discrimination when it comes to people, because that's protected under the Canadian Charter of Rights and Freedoms and human rights legislation. You don't discriminate by the individual that owns the property. You discriminate by the location. And it's a discretionary decision. So it rests with the local government to make a decision on the zoning of land. Unlike other provinces, British Columbia does not have an appeal tribunal, which will decide on quote unquote good planning principles or some other characteristics, what the proper planning and land use management decision is. As the elected officials, you folks are given that power. You folks are given that power. We do not have constitutionally protected property rights in Canada. The courts and government recognizes that a person cannot do whatever they want with their land. When you purchase land, you're given a bundle of property rights. And starting from the highest level, there is local government control over the use of that land. So essentially, when it comes to planning and land use decisions, the buck stops with the elected officials. Now, having started with that great picture of the amount of power and the breadth of that power and how discretionary that power can be, we now have to step back and consider the framework that we're working within, because there are a number of clawbacks. So perhaps it's because of my Sicilian heritage with my parents. I was born in Canada, but I'm going to start using my hands now. And I'm going to start using my hands to describe a couple of different concepts, and you're going to need to bear with me because those concepts are going to change. But for now, let's talk about government. As a gross oversimplification, our Constitution Act set up two heads of power: the federal government and the provincial government, right? And sections 91 and 92 of our Constitution Act divvied up the powers of the country into those two categories. And things like local government, which were characterized in the Constitution as municipal institutions. Now, local government includes municipalities and regional districts, but that's the purview of the province, listed right between asylums and taverns in our Constitution Act. And later down on that list, we have property and civil rights. And then later down on that list, we have all matters of a merely local and private nature in the province. So the power that rests in these areas has been given to the province, unlike, for example, the federal government, which got things like the military, navigation and shipping, criminal law is a federal matter, and there's a whole host of other things, banking and so on. So it's important to understand in the principles of law that local governments are essentially a creature of the province. You've heard that terminology before, but it essentially means that there is no constitutionally recognized form of local government. It is a creature that the provinces have created. Now, the reason why that's important in law is because where you can have legal authority, and this rests on the earlier question that was come, the province can only delegate the authority that it has. Right? And once delegated to a local government, the province actually sets out in the legislation which of those things can be further delegated and what cannot be further delegated. And just as a quick preview, I'll say that the section identifies that anything that can be done by resolution can be further delegated, but if it's the requirement that the local government do it by bylaw, that cannot be further delegated. Now, so one of the substantive clawbacks are the things that the federal government is responsible. You have no land use jurisdiction over, so you don't have any jurisdiction over the base. right? You don't have any jurisdiction over land owned by the federal government. You don't have any jurisdiction over criminal matters. And we know planning and land use can get pretty heated sometimes, and those things come into play, but you have no jurisdiction over that. You also don't have jurisdiction over things that the province has not given you. So as I said, the province has delegated quite a bit of authority to local governments and the regional district, in particular through Part 14 of the Local Government Act is a section that deals with planning and land use management. Part 13 deals with with regional growth strategies. Part 15 deals with heritage, but in a regional district context, you need to have a heritage service to actually use any of those powers. So that's quite a bit of authority, but they've also held things back, what I refer to as clawbacks. So the easiest examples are mining, forestry, agricultural land reserve. Those things are still under the control of the province in other frameworks. So we've had a couple cases, just to use mining as an example. If something is authorized by the province in a Mines Act permit, then it ousts your land use jurisdiction over that. So both the Cowichan Valley Regional District challenged that a few years ago, and the District of Highlands also challenged that last year as well. We've got cases from the Court of Appeal, which very much limit local government's authority when it comes to the Mines Act permit, what's authorized in a Mines Act permit area. Now, the province may consult, they may send a referral to ask you what your comments are. So you still zone land the way you want to zone land. You still identify your concerns, but they largely might ignore them from a land use and zoning perspective because of the higher provincial oversight over that. They've given the power, but they've held certain powers back. We see other examples of this, for example, when it comes to daycares. Daycares under 8 persons are allowed to exist in single-family dwellings, whether they're zoned for that use or not. And we cannot say, and from a zoning perspective, that use is prohibited. Now, what you can say is, well, okay, the buildings that do have daycares, we don't think they should also have a secondary suite, or we don't think they should also have other home-based businesses, right? So you try to avoid sort of the overuse of land, for example, or the wrong mixes. I was given this presentation once to a local government that one of the councillors was a daycare operator and working out of a house, and the basement suite was occupied by somebody who was on the list, right? And so that was one of the things that local government did, was to avoid that in the future, is have daycares can operate, but then you can't also have those other uses. So there's just some different things we can do from a planning and land use perspective to meet the community's desires and goals for proper planning. So I've gone over some of the clawbacks, things held back by the province, things that are under our constitution because things are split up between the federal and the province. Navigation and shipping is with the federal government. So yes, your zoning goes out into the water, but if it deals with a matter that deals with navigation and shipping, there may be a federal exemption there to that. The local government also has a catch-all 584, where the minister can essentially declare a local government bylaw invalid because the province finds it to be contrary to the public interest. Now, apparently that power hasn't been used yet, but it's there, and it shows that despite there's been so much power that's been given to local governments, there is those clawbacks, and there's the potential for more clawback. Now, some of the substantive constraints, I mentioned briefly the Charter of Rights and Freedoms and human rights legislation. And so an example, and so we don't discriminate on the basis of individuals, but we also don't, for example, it affects things like freedom of expression. So one of the planning powers is the power to regulate signage in your community. Now, because of the Canadian Charter of Rights and Freedoms, you're not actually dealing with the content of the signage, what words are put on those signs. You can talk about the fonts that they can use and the size of signs and so on, but the actual message is something that's protected under freedom of expression. But also, it's difficult to prohibit signage completely. So a prohibition is automatically considered a breach of the charter, right? And so you get into the situation where you then have to defend and rationalize and justify the provision for it to be a constitutionally valid prohibition. And there's a case law from a few years ago from down the road out of Nanaimo where there was a prohibition against, spinning signs by the highway, right? And what that community did is they allowed it to occur for new businesses for a short period of time, but otherwise wasn't prohibited. So they met their objective of the aesthetics of the community, the safety of traveling along roads by not having too much signage and so on, but also balanced it with the ability for new businesses to get established in that manner. So that was some of the balancing act that goes on when you try to factor in the various charter rights. Now, some of the other substantive constraints on your authority are a practical constraint. So, for example, you want to exercise your authority generally in a matter that doesn't trigger compensation to property owners. And it's important to note that our legislation sets right from the outset. I'm not going to read to you too often, but I'm going to do it right now. Section 458 of the Local Government Act says compensation is not payable to any person for any reduction in the value of that person's interest in land, or for any loss or damages that result from, and then it lists any of the following: official community plans, zoning bylaws, a whole host of other planning and land use regulation powers and bylaws, and the issue of permits, and there's a few more. So we start, you may often hear this complaint, it's going to affect my property value, and you can't do that. You have to reimburse me. You do not have to reimburse anybody. You do not have, but it does have an exception. And here's the exception. The exception is if those bylaws restrict the use of land to a public use. So generally speaking, you're not taking private property and the only use of land you give to private property is a public use, right? So right now, you may have heard we've got the city of Halifax. Now, planning and land use management, remember I said it's a provincial thing, so each provinces have different planning frameworks. But some of the principles apply across the country. Is dealing with a situation where they're facing a complaint from a property owner that the city has been putting out their land, which is private land, for use as public park. And so it went to the Supreme Court of Canada, not on that principle itself. It went to, as a preliminary skirmish, a preliminary legal skirmish, went up to the Supreme Court of Canada, and the Supreme Court of Canada said that that property owners actually is allowed to argue that point and argue the case law around this. So it will eventually make its way back up of whether compensation will need to be payable in that case, and that'll be a full review of the facts and so on to do that. But generally speaking, it's fairly easy for us to draft bylaws in a way that doesn't trigger the compensation requirement. But it's something to be aware of, because that's usually one of the things you want to do. Now, one of the other substantive constraints, when I say, constitutionally, we don't have entrenched property rights, if a property owner has established a use lawfully before there was a local government bylaw that said that use is not permitted, the law, both government law and judge-made law, law in the courts, protect that as a non-conforming use. So the status quo is protected. They are allowed to continue that use, but they then enter a regime where it's somewhat more constrained what they can do with the land and the building that is considered lawfully non-conforming, right? So you can have something that doesn't comply with your bylaws that is still lawful. And now if that would be on the basis that it was established lawfully at the time. The legislative framework is such that eventually it should comply, right? So you have some rules, like, for example, if it's burned down or destroyed more than 75% of its value above the foundation, if it's less than 75%, it can be rebuilt and continued. If it's more than 75%, then it has to then comply with the laws, the bylaws that are passed at the time. And there's a whole host of other rules. So when I say, that's a protection for the property owner. Now, that's a nice segue into other constraints that you have on the exercise of these significant planning and land use powers that also end up being protections for the public and residents through procedure. So I'm going to use my hands again to describe a different concept here. So I had first done the governments and the federal and provincial, and I'm now going to group them over on one side. So we have government-made law. So as a gross oversimplification of where law comes from, we have law made by governments, and you're included in that as a local government. And then we also have law that's made by the courts, and that's through our British tradition of hundreds of years of case law and judge-made law, where it's called the common law is what it's referred to. And this is essentially law that is made by judges. See, the courts serve a few different functions in our society under the rule of law that we operate within. One obvious thing is they resolve disputes, right? So if people are in contractual arrangements and they have a different dispute over the contract, they're a dispute resolution tribunal to resolve those disputes. But courts also interpret government-made law. That's called the exercise of statutory interpretation, because those can be subject to more than one interpretation. We're going to loop back to statutory interpretation a little bit later. But the other thing they do themselves is courts make their own law. Judges make their own law. And the easiest example to use dates back to the 1890s in a case of Donahue versus Stevenson, when an individual was made sick through a rotten snail that was found in their bottle of ginger beer. And there was no government law that said you can't do that, or the person or the company needed to provide a remedy or compensation for having made the person sick at the time. There was no government law that said that. So the courts created one, and that's the law of negligence. And now it's evolved far past that situation. We have government statutory versions of negligence, and we also have the common law version. Now, the reason why I mentioned common law and judge-made law at this point is when you look to you're using your planning and land use management powers, a lot of the rules are set out in the legislation, right? The fact that you have to give notice before certain decisions are made. The fact that some bylaws require a public hearing. That's set out in the legislation. But there's also another set of rules that's not set out in the legislation. Those appear in the common law. They've evolved through judge-made law. And so it's not enough to just look at, as much as I encourage your planners and staff and even yourselves to go and look at the legislation, that's often incomplete because there's all this law that's made by courts. And the easiest example to use of that is when you're holding a public hearing, legislation says you need to have a public hearing, right? But the principles of procedural fairness require that documents be made available to people so that they can speak to the bylaw. The legislation only says that you have to have the bylaw available. That's what's identified in the notice, where the bylaw can be inspected. Now, the courts have said, looking at the bylaw is not enough. To be able to expect people to make representations, they need to know the same information that the decision makers know. Right. So whatever information that is given to you, either from the applicant or from professional studies, staff reports, so on, that same information is available to the speakers so that they can comment upon it. So that's an example of there's one rule that's in the public, that's in the legislation, and it's supplemented by rules that's have been passed down through the courts. And so, you know, coming back to the significant amount of planning power that I talked about, those rules are different depending on the power. Some have notice requirements, some don't. Some have public hearing requirements, some don't. So it's important to know in any given situation what the procedural requirements are. Now, I say, and also, some of those rules are not specific to the planning powers, but they govern how you operate. For example, open versus closed meetings, right? That applies to the board, applies to the committee, and applies to a number of the functions and the committees and commissions that a local government may have. Generally, decision is made in open meetings. And there is a limited list of things that must be done and closed. So the community charter sets out both a list of what must be done in a closed meeting and also what may be done in a closed meeting. So the receipt of a solicitor client privileged advice, the receipt of legal advice is usually done in a closed meeting. We're an open meeting today. I'm not giving you legal advice. I'm just reviewing the framework for planning and development law for everyone's benefit. So those are some of the general rules apply that, and that applies to all the exercises of your powers, not just the planning and land use ones. The other thing I wanted to highlight is it's important for you to understand how decisions are made, how local governments make decisions. And so when the province has delegated power down to local governments, they've identified essentially, again, as a bit of an oversimplification, but there are basically two different ways to make decisions as a body. You can do them by bylaw or you can do them by resolution. Now, knowing which way you have to do things influences the amount of procedure that it's involved, but it also influences a number of other rules. For example, what can and cannot be delegated. So if you just look at your planning powers and you see that is a power that has to be done by bylaw, that's not something that can be delegated. So zoning bylaws, zoning bylaw amendments, those have to be done by bylaw, where, for example, development permits, well, your development permit framework is put into your bylaw, mostly the official community plan. There are guidelines and exemptions which are allowed to be in a zoning bylaw, but the rest of the development permit framework, and sometimes they are not, usually it varies across communities, right? So by bylaw, it's in the official community plan. But then when it comes to actually make a decision on a development permit, that's done by resolution. So that's an example of a power that can be delegated, whether it's from the board to the committee or the committee down to, or from the board down to staff. Right. I'll pause here to note that one of the other rights that property owners are given by the legislation is the right to make an application. Okay, whether it's to amend a bylaw or to have a permit issued. So I've said earlier that they don't have a right to use the land the way they want to if it's contrary to the bylaws, but the legislation protects that they have the right to apply to the decision maker to have that bylaw changed. And what that entails is that you have to consider their application. Now, what that doesn't mean is it has to go to a public hearing. It doesn't even mean that it has to have readings if it's a bylaw, right? So you can consider it and say no fairly early in the process. But you have to consider. And now what you're considering is the application that they had, that what they've submitted. Now, with a lot of planning powers, and I'm going to come back to the discretion point, there's policy that informs it. So you have a professional staff that gives you advice, but your professional staff is also, in many senses, trying to aid an applicant, right? To get their application to align best with the policies that you've already established through things like your official community plan, the regional growth strategy, and other bylaws. So not only would they identify what bylaws need to be amended as part of an application, but if there's more than one way to come forward with an amendment application, they may try to negotiate that in a certain way, using their professional judgment and so on. And that's generally fine. But if the applicant at the end of the day doesn't accept a suggestion and they want something to come forward the way they want it to come forward, they're entitled to have that happen, just as much as your staff is entitled to give you an opinion, even if that opinion is we recommend against this, right? I also sit on the board of the Planning Institute of British Columbia, and as a registered professional planner, we have our independent professional planning opinions and our own code of conduct and ethics that we're bound by, which includes duties to the employer, but it also includes, the duty to have that professional judgment. So I use as an example, because I get this question usually, it's not as often anymore, but it's at least once a year still. The idea of having a hold or having a development freeze, things like that, or we've just passed a new OCP. We don't even want to consider people who, applications to amend it. So a policy like that is fundamentally a bad policy. You can't just, refuse an application or refuse to consider an application. It may not get very far, but you still have to consider it. And that's the protection that property owners are given under the legislation. Now, one of the other concepts I want to get into is, again, I'm going to start using my hands again now for different things than I used them before, is the concept of discretion. I've already hinted at it a little bit. Zoning is a completely discretionary decision. Now, I like to refer to the spectrum of decision-making authority when it comes to discretion. So at one end, you have complete discretion, and zoning fits in that category. And on another hand, there's no discretion, and something like a building permit fits in that category. First of all, you don't even see building permits, except maybe as an informational item, and some communities still do that. But building permits are made, those decisions are made by building officials who essentially, it's a tick box. Has everything in the code been identified? Has everything in the bylaw been identified? Has that been met? And if they all are done and all the bylaws have been complied with, it's a permitted use and so on, then a person is entitled to their building permit. And there isn't a residual discretion that says where, the decision maker can say, oh, I don't like the look of that, or I don't like, whatever it is, to deny that building permit, as long as it's met all the requirements. So those are your two extremes. And the reason it's important to understand where you are in this scheme is it affects how, first of all, staff operate. It affects how you as a decision maker operate. But it's also important to the courts because, for example, on the building permit side of things, if there's no discretion in your decision or the decision of the official, then if a person is aggrieved for having not received their building permit, they can go to court for what's called, we still use the Latin terminology, mandamus, which essentially means to compel the issuance of the permit. And if a court agrees with them that they've met all the requirements, then the court will actually order the permit issued, right? Whereas on a zoning, a court will not make a land use planning decision. Instead, it will not substitute its view on a land use planning matter for the view of the elected officials. So if a property owner doesn't get a rezoning that they want, that doesn't get the use that they want, for example, for their land, they can go to court. But if they're only going to court on the fact that you've made an unreasonable decision, or they should have a court won't say, I'm going to substitute my use. They won't evaluate whether the substantive decision is fine. They may evaluate whether you had the jurisdiction to make that decision. They may evaluate whether you followed the procedures properly, right? And if necessary, they'll correct that, but they won't substitute their decision. So essentially what happens there is remittance, or a bylaw may be quashed, but they won't substitute their opinion, their planning and land use opinion, for your opinion. They'll send it back for you to make a decision that is within your authority, that has been done procedurally correct. So that's really important to understand. And that's why I say that it's quite a phenomenal amount of power, that zoning is inherently discriminatory and a discretionary decision. Now, development permits is not a completely discretionary decision. It's what the courts refer to as limited discretion. So the development permit power, this is the power that you have, the forming characters of common development permit power, but it can be other things as well. Protection of the natural environment, protection of development from hazardous conditions, protection of farming, energy conservation, greenhouse gas reductions, water conservation. The purposes are set out, and we can have a separate section on development permits that go into that into more detail if the committee would like. But generally speaking, the decision-making around development permits is what the courts refer to as a limited discretion. So it's closer to the building permit side of the spectrum than it is to the zoning side of the spectrum. Now, this is because the official community plan has built up a development permit system under the authority of the Local Government Act. The Local Government Act dictates that there are mandatory requirements to make such a development permit system work. First of all, you have to identify the area that it's going to be in. You have to identify the purpose of the designation, and the Section 488 of the Local Government Act sets out 10 different purposes, and you can have more than one purpose. You identify the special conditions or objectives, and as a lawyer, I usually say do special conditions and objectives, even though the legislation says or. You can, it's better to do both, of that justify the use of this fairly extraordinary power, right? And so that all needs to be laid out. And then on top of that, you can have exemptions. So if you capture, certain things that you want to let out of the scheme, you can exempt them, and that needs to be laid out. But then you have the things you hear about most, which is the development permit guidelines. And the guidelines are essentially the framework by which the development permit system gets implemented. The way the purpose is achieved, the way the special conditions and objectives are addressed. And so your decision-making is constrained by those guidelines. So when it comes down to making a decision on a development permit, you have to look at those guidelines and say, is what I'm interested in talking about covered by these guidelines? Because if it's not, then it's not something you can bring into your decision-making. Now, I do want to say that This doesn't mean it's not a no discretion decision. There can be more than one interpretation of a set of guidelines. And this is because guidelines generally tend to be flexible. There's sometimes there's shoulds and mays. Other times there's musts that are more mandatory, right? But even in a situation where there's a must guideline and another must guideline, and they're kind of competing with each other, there's more than one reasonable way to balance that. And so the applicant will certainly have their interpretation of how they've met the guidelines. Staff may or may not agree with the applicant, and staff may support that interpretation or may have an alternate interpretation of how the application does or doesn't meet the guidelines. If there's a question, you are only allowed to make a decision on that. You are only allowed to approve an application if it has met the guidelines. If it has not met the guidelines, you're actually not allowed to approve a decision. So if there's a doubt as to whether a guideline has been met or not, you need to deal with it in terms of what's the balancing act. Is there a competing guideline? Is there an appropriate way to deal with it so that the application can still be approved if that's the direction that you want to take? Even if something comes forward to you and the message is all the guidelines have been met, the decision maker is allowed to reach a different interpretation. But there's obligations on you if you're going to do that, right? So if you have a different interpretation of the guidelines, you are obligated as part of the principles of procedural fairness to tell the applicant what your interpretation is. Right. And so you have to give reasons, which in the zoning world, we don't have to give reasons as a body, right? You'll often as individuals say your reasons, but as a body, you don't have to agree on one set of reasons, right? You have a vote and you talk about what informed you. But as a body, you would identify through a resolution what an applicant must do to change their application to meet your interpretation of the guidelines. So not only to tell them what your interpretation of the guidelines is, but how they actually have to change their application. So that if the applicant actually does that, the next time they come forward, their application is approved, right? So that's that limited discretion. The courts will still give you deference as long as you have a reasonable alternative interpretation. You've shared that with the applicant. The courts have gone so far as to say it's not a guessing game. You can't just say we have a different interpretation and leave them to figure it out. You have to share that with them and make it easy. And if you don't, then the applicant may be aggrieved and may go to court, and a court in that case might actually mandamus or compel the issuance of the permit. They might not say send it back. And so we have some examples through the case law where things have gone sideways. Where, for example, there's a case out of White Rock, Yearsley and White Rock from a few years ago, where it was a 6-story building. It was a forming character development permit area. The 6 stories aligned with the zoning, so there wasn't a question that it was too high according to the zoning. It met the bylaw requirements. But the city had a public hearing, which, interestingly enough, for a development permit, you're not required to have a public hearing, and you're not required to even give notice, right? And it might be because you have a limited discretion, and the document that the development permit framework is in your official community plan, which actually has the most consultation of any of the planning documents, the most required amount of consultation. And so maybe that's informed it. And as a planner, I've done a lot of my education with collaborative based decision making, consensus building, promoting public consultation. That's part of what my master's work was in. But the lawyer in me says, development permits are not a good idea. Because if you're going to accept consultation on that, you basically have to tell the public that we can only hear Actually, you can hear more. We can only have a difference if it's relevant to the development permit guidelines. So what happened in White Rock, a lot of people came forward and complained about the height of the building. And there were no guidelines that dealt with height, is what the court ultimately concluded. And so when council turned that development permit down, the property owner went to court and essentially got their development permit issued. And those elected, and the court systematically went through the reasoning to basically lambaste the elected officials for, making a popular decision, but wasn't consistent with their authority. It wasn't that they weren't exercising the appropriate level of discretion. They weren't aligning with the guidelines. And it's interesting enough that Salmon Arm, a case much earlier, where there was also a height issue, there were guidelines that dealt with the height, and the bylaw permitted a maximum of 3 stories, and council in that case said, you know what, we don't want a bunch of 3-story buildings. Let's have a 2-story building, let's have a 3-story building, let's have a 4-story building, let's mix it up. Right? And the court said that would have been okay because that felt within the height guidelines, except they forgot to give a variance. And so the zoning bylaw only permitted a maximum of 3 stories. And so they couldn't actually require that 4-story building because that would have required a variance or a change to the zoning. So they couldn't have forced the developer to do a 4-story building. But the principle of once there was a guideline, they could deal with the height. The developer in that case was still given the amount of density that they were entitled to under their zoning, but it was just in a different form and character way. So knowing what the discretion you have affects the range of your available decisions. It affects the remedies for applicants and developers. And it also affects communications as between staff and the applicant. If it's a discretionary decision, there's essentially more room for quote unquote negotiation. And that can be done in furtherance of the policies that you have or otherwise making an application kind of come forward with its best foot forward, so to speak. I'm happy to take questions as we go from committee members if you like, but otherwise I'll just keep going on. Now it's important to know that others have decision-making power too. This is a part where you don't necessarily like hearing from me, but as much power as you have, there are certain things where the decisions are made by others. So for example, subdivision is one of those things where the subdivision approving officer is an independent authority under legislation. Also another fairly unique British Columbia thing that has their own obligations under the legislation. And in the regional district context, it's separated because it's the provincial subdivision approving officer. And they may refer things to you and you comment back on it. And you have different ways to influence subdivision. For example, through your bylaws, because the approving officer must comply with your bylaws. Now, some of the other things, an approving officer has a generic authority to not approve a subdivision if it's what's considered against the public interest. Now, they're allowed under the case law to consider things like your official community plan. But we find that at the regional district level, vis-a-vis the province, that separation often leads to a situation where the approving officers may not be as may not be as comfortable refusing an application based only on official community plan policies. So there's been times when I've worked with regional districts. For example, some of your powers that are in your OCP, you can translate fairly easily into zoning. or into one of your other planning powers. But some of the other powers, some of the other policies you might have, like for example, around parks and trails, that's hard to translate into zoning. So getting a trail at a subdivision stage is actually it's perfectly lawful. The approving officer has the authority to do that. It's a perfectly convenient time to do it, even though the legislation allows that to be done, and the courts allows that to be done without compensation, just as a condition of subdivision. I've worked with regional districts where they were willing to pay for the trail, but the provincial approving officer wasn't wanting to make it a condition of the subdivision, despite having the legal authority to do so. So there's this tension that's there that can sometimes be negotiated through. Also, the province has sort of gotten out of the habit of holding covenants themselves. These are conditions that are put onto. So let me pause for a moment and just say what a covenant is. Again, let's go back to government and common law. Common law, there are historic property contracts that are a special brand of contract. Now, under the law of contract, one of the fundamental principles is the privity of contract, and that is that a contract is only binding against the people that sign that document. And it's only enforceable against the people that sign that document. Now, in a property law sense, there is what's called the common law restrictive covenant, which is essentially a contract between two neighboring property owners where one property is burdened and the other property benefits from that. And that's a special type of contract because through, again, the common law principles, that was made to run with the land. So not only is it binding on the people that signed it, it's binding on all the subsequent property owners. Now, under common law, to have a restrictive covenant, you had to be two adjacent property owners, and that doesn't work very well in the context of government, right? And so government-made law, the province, under Section 219 of the Land Title Act, and this dates back to the 1960s, under 24A of the Land Registry Act, developed a tool which was the statutory version of the common law covenant. And so it didn't have to follow all the judge-made rules. So first of all, you don't have to own an adjacent piece of property. Second of all, these were called restrictive covenants because they can only be restrictive. The rule under common law restrictive covenants was if you had to stick your hand into your pocket to spend money, it wasn't a valid restriction, right? It could only stop you from doing things, not require you to spend money to do things. Whereas Section 219 statutory covenants can be both positive and negative. They can have restrictions and requirements. They deal with use, building, subdivision. So it's a tool that's used quite commonly at a rezoning stage as part of a rezoning negotiation. If somebody is promising certain things that come with their development and the local government wants to have a legally binding agreement to enforce those promises that are made, then you can do a covenant to have that. It's done at the subdivision stage as conditions of subdivision, like somebody will only get their subdivision if they have a covenant post on their land that X, Y, or Z needs to be done before there's building. We see it very commonly in floodplain situations. Other hazard scenarios, permits are only issued or exemptions are only granted on the basis of a covenant that registers a report that lands can be safely used upon. It includes an indemnity to protect the local government from a financial perspective. But those are all essentially a type of contract that's put on. And then the subdivision context is the province doesn't really want to hold covenants anymore. They used to do them all. They used to, more than 20 years ago, did all the floodplain work. They've now passed that down to local governments. So they ask regional districts to hold those covenants. And so that's part of the negotiating authority a regional district has, is how it and its willingness to hold the covenant. I'm going to come back to covenants later if you have any questions on that, but I just want to highlight one of the other decision makers that's out there is the Board of Variance. So you make decisions, the local government and the elected officials to pass a zoning bylaw, but then there's this entire body of appointed people that can change that. Now, this is because, and the Local Government Act requires anybody who has a zoning bylaw to establish a Board of Variance. Now, Board of Variances have fairly limited jurisdiction. It's minor variances made for in situations of undue hardship. They're not dealing with use, density, floodplain. They're not dealing with the big things. They're dealing with siting, size, dimensions. So setbacks, height, those kinds of things, placement of mobile homes, that sort of thing. There's a short list of things that they can cover. But within that framework of their authority, they are allowed to essentially change a local government's decision. Part of the rationale for that is well, your communities are large. And so when you, and undulating and all sorts of, so establishing a zoning bylaw inevitably is going to have parts of the land where it just doesn't work, right? Either there's rock outcroppings, whatever it is, that the intended framework of how heights get calculated, setbacks don't allow a reasonable opportunity to build. And that creates what's called the undue hardship that the Board of Variance can then grant a minor variance. And then, so in terms of the other decision makers, the local government can also delegate decisions. And so that's where you can voluntarily bring in other decision makers. Now, when decisions get delegated down to a lower body, like I said, the province identifies when that's okay and when that's not okay. And when it is okay, what's usually included with that is reconsideration by the decision maker. So if the applicant gets their permit, then you'll never see it. But if the applicant is denied their permit from, say, for example, if something's been delegated to staff, then that applicant can have the decision-making body reconsider that. So even if the board does delegate things down to you or to staff, things can end up going back up to them in certain situations. Now, one of the other constraints on your decision-making authority comes from your own individual situations. So there's conflict of interest rules, right? In certain situations, it's not you as a body that's constrained, it may be you as an individual where you have to declare a conflict, whether it's pecuniary or non-pecuniary, but also part of the law around procedural fairness is, generally speaking, here to keep an open mind to decision. When I mentioned earlier that applicants are entitled, they're given the right to apply, to make amendments, to apply to make have permits issued, and to have you consider that. And that means you have to give it consideration. You can't, spin your chair around and turn your back on these folks and say, I'm not even going to consider this because I totally disagree with this right from the get-go. I'm not even going to bother to hear you. Let's move on with this as soon as we can, right? I don't make this stuff up. This is what happens, right? And that we then as lawyers have to advise on. And so what we talk about is keeping an open mind. That doesn't mean you have to agree with them, but you have to hear them out. You have to consider. We just this morning I was reading a case that was decided last week out of the Sunshine Coast Regional District, where the court pointed out that it was not proper for the decision maker to just refer to the staff recommendation, to just, as the way the court put it, was rubber stamp it. Now, in that situation, the applicant had submitted quite a significant amount of information. The judge got the impression that certain of the elected officials did not actually read through it or consider it, but instead just sort of deferred to staff. And the court said that wasn't proper consideration. That wasn't procedurally fair. You can ultimately end up agreeing with staff, but you still have to go through the material and consider it. Right? So the problem wasn't that they agreed with staff. The problem was that they didn't actually go through the material to reach the position where they could then be considered to have considered the information and the application. I've already hinted at there's a difference between public law and private law. So public law, private law are things like the law of contract. Public law are things like bylaws. Now, just because you're a local government and you enter into a contract, that doesn't make something public law. Just because you can enter into a covenant with a private property owner that runs with the land, that doesn't take it out of the realm of private law, contract law, and make it public law. Now, I say it's important as a decision maker to understand what framework you're working within, because it affects enforcement later on. It affects the administration of what you're doing. And generally speaking, as lawyers, we try to steer you as much to public law to facilitate later enforcement. So for example, when somebody's breaching a bylaw and staff are instructed to enforce against that, usually through the policies that you have established ahead of time, but sometimes through specific resolution about escalating levels of enforcement. What are some of the complaints you usually hear from people when you go to enforce a bylaw? Some of the more common ones are, my neighbor's doing the same thing. And this has already been happening for 10 years and now you're enforcing it, it's too late, right? When you're dealing with public law matters, the courts don't have the time of day for those arguments. Those are I shouldn't say they don't consider them, because they still consider things, but those arguments have often been made and always been rejected, right? When you're dealing with private law contracts, those arguments actually factor in to defenses that are available to someone who's breached a contract. So for example, if someone's operating in compliance with their zoning, but not in a compliance with a section 219 covenant that's operating on the land, because covenants can often restrict those available uses or say that those uses can only be done in a certain way, then it's more important to enforce those more quickly and be a little bit more vigilant about it, because to avoid things like the defense of delay, latches, and acquiescence. And there's a case of the Capital Regional District and Millstream Properties from a few years ago, where the CRD didn't enforce, somebody was acting in compliance with their zoning, but contrary to a covenant. Right, because their zoning, the zone that they operated is one of these zones that had like 30 uses that were permitted uses. But when they got that zoning for their land, a covenant was put on the land that says, even though there's 30 uses, you can only do these 10 or 15 or whatever it was, or you couldn't do these other ones, which is a completely lawful thing to do if that's part of, because you have a discretionary zoning decision. And if the property owner is willing to give you a covenant. So the property owner was in that case, but then I'm not sure if it was them or the property was sold, but they started operating in compliance with their zoning, but contrary to the covenant. And it took CRD 6 years before they went to enforce that. And the court said that was too late. You took too much time. You slept on your rights, was what the judge said in that situation. So it's important to know whether you're in a public or private law context. And I'm going to wrap up soon unless you have any questions. And one of the things I wanted to highlight before I wrap up is you have many powers. Local governments have many powers. And some of those are legislative in nature, passing bylaws and enacting bylaws and resolutions. And some of those are business powers, dealing with the development, disposition of land, and so on. And some of those are, the court refers to as quasi-judicial, where you're making a zoning decision on a specific property or an individual's property owner's rights will be affected by what you do and don't do. And those things have different requirements on you. It refers to many hats is how the courts run. And they say that the legislative framework that you're working in, conflicts are inherent in the system. I'm not talking about individual conflicts. That's a different thing, the pecuniary and non-pecuniary, but just the conflicts between these different powers. They're inherent in the system and they're not necessarily sinister or wrong, is the quote that's been used there. But what must be done is the decision maker must carefully manage these conflicts. That's what you have experienced senior staff to help you do. And make sure you follow the procedures that are appropriate and you keep an open mind for the decisions that you need to. And you don't let your court, the way the court put it is, let your business interests overwhelm the ability, your authority to make good law. So that came out of a Vancouver case where essentially there were two adjacent properties, and one of them was an affordable housing building, and that was quite dilapidated. And so the city owned one of these properties and a developer owned one of the other properties. And they wanted to do basically a land swap and extra density for the developer to build a private development. And the developer was going to build the city an affordable housing building as part of this whole deal, as part of this whole business arrangement. But it was all conditional on the rezoning for the extra property. So you cannot promise as a local government to give a rezoning. That is a legislative decision that you make on consideration of final adoption of the zoning amendment bylaw, right? And ahead of time, you cannot promise to do that. That's called fettering your legislative discretion. But what you can do from a business perspective is say, we can set up this whole business deal that essentially falls apart if you don't get the rezoning. So it's not a promise to give the rezoning, it's the rezoning is a condition on the rest of the deal working. But otherwise, you still have to go through the proper process and consider public input and all of that. So you don't end up making a sham of the public hearing process by agreeing to something ahead of time that you can't agree to. So we do those deals all the time where it's subject to a rezoning and then you go through the procedure. Now, so the City of Vancouver did that, and the Court of Appeal ultimately found they did that properly. What one judge found at the British Columbia Supreme Court was the community association that challenged that said they hadn't gotten all the documents so at the public hearing so that they could comment on what was happening. And the judge agreed with them at first instance. But what the Court of Appeal clarified was, hold on a second, what they were entitled to were documents related to the rezoning. They weren't entitled to documents related to the business deal, whether it was a good business deal or not, what was the value of the affordable housing units or so on. They were entitled to what was the zoning question that was being dealt with for that property. Should they have extra density? Because the use was already permitted, but should they have extra density and extra height? So those were the documents that the public was entitled to, not all the other documents, because our legislation, when you do a property disposition, doesn't require a public hearing. It only requires you to give notice of what the consideration is, the property, who's receiving it, and so on. It doesn't require a public oversight over that decision. It is a business decision that the local government makes. So that clarified that those many hats, that you have to carefully separate them, and the ones that require that public process have that public process, and it's done procedurally fair and so on. But just because one component of the deal requires it doesn't extend to everything else. And with that, I mean, I could go on all day. Each of the topics, zoning, official green plans, regional growth strategies of development permits, each of those different individual planning powers are quite involved, and I'm happy to go on a little bit longer to describe some of them, or I'm happy to answer some questions, or we can leave it with that bigger framework, and I've given you some resource materials that you can look at on those specific powers. I'll take direction from the chair.
Thank you very much. That's a lot to absorb. We're going to have a flash quiz right after this. Everybody's got their notes. So do we get a diploma if we pass?
Sure, yes.
It's a lot to absorb, and it really makes you very appreciative of the work the staff does in sorting all this kind of stuff out. But certainly it's a really good overview of what we have as far as our powers and discretion. I think we have a couple of speakers wanting to speak. Anybody, Director? And we do. Director Robert.
Yeah, thank you. And I do appreciate making this part of the orientation. I think it's very useful to have you here to kind of really clarify and explain a lot of what drives our decision making and what makes it hard as well. I do have a couple of questions, and I'll just describe them as general situations because I think you did a good job of explaining, but I think sometimes for us, things can fall a little bit in that gray area. So earlier you said in regards to zoning, we do have quite a bit of authority. And one question I asked last term, but that never really got tested or that I never brought motions towards. You started your discussion talking about quite often there's not compensation necessarily if there's a change of zoning. So to what extent because there's a few examples in my area where you have properties that are not aligned just through history with current OCPs. So the zoning and no activities maybe, or in some instances, some activities, but let's stick with those that haven't had activities. They haven't necessarily had the activity. So you have historical zones, say that it was a commercial one, right? But really in today's context with your OCP, say elected officials said if we wanted to make it more consistent with our OCP, this should be an R1, right? This should be so this is this historical commercial property that's sitting there and nothing's happening. So can this board initiate a rezoning process for that property to change it from commercial zone 1 to residential zone 1? And what would that look like? And then I'll have one more question after.
I would like to answer in two parts. First, in a very specific part, and then one in a general part, because the very nature of your question prompted something that I probably should have highlighted as well. First of all, the board has the authority to change anybody's zoning at any time, right? The exercise of that authority needs to go through procedures, right? But also be consistent with a couple of different things. This is the official community plan and the regional growth strategy. So the exercise, so here's the thing is, because I don't want to go into too much specifics about your specific example, but it highlighted that if there's an official community plan designation and zoning, and those two aren't presently aligned, a property owner's development rights are still determined by their zoning, right? But to the extent that what makes an official community plan quite a powerful document, as more than just official community plans are often referred to as vision statements of where things should go in the future, right? But it's much more than that. And one of the things that once something is in your official community plan, all bylaws enacted afterwards and services undertaken must be consistent with that official community plan. Now, the existing zoning, if it's inconsistent with the official community plan, that's the legislation doesn't require you to go in and change the zoning right away. It just says that when you do change the zoning, you must make it consistent with the official community plan. And in the meantime, the property owner can still use their zoning. So yeah, if you do, so one of the questions I often come to in working with local communities is how much of an immediate effect do you want your official community plan to have? Is it going to be something that the local government itself initiates new zoning to then align with the official community plan that it's just gone through an exercise to do? Or are they gonna allow people to still use the zoning that they have? And it's only when they want to change that zoning that they then align it with the official community plan. So these are questions that local governments go through. So that's the longer answer, but the short answer is the board can decide at any time to initiate a rezoning of a property, whether it's an entire community or an individual property.
Thank you. That's,
And to make it align with the official community plan is a good reason.
yeah,
There are some reasons that, you then kind of evaluate. Remember the framework I said is, are we doing this for individuals, or are we, which we do avoid on a charter basis, discrimination on an individual level. If you're wanting to change the zoning just because a property owner owns that, then that wouldn't be a good purpose. But if it's to make an alignment, if it's to deal with a property situation as opposed to a personal situation, then that's very much a defensible and appropriate purpose for rezoning.
great. Thank you. I have to say, I also realize that your feedback and responses is not necessarily going to be applicable to everything that we encounter. And as you say, some of it lives in the specificity of each of those streams of what you're dealing with. But I wish I had some of the information a few years ago, to be honest. What I'm finding is we have quite, probably like everywhere in BC, you have quite a colonial structure around your zoning and your things. And I think there's a lot of excitement at municipalities and regional board to redo your OCP. And I think that, unless you correct me, I think the tendency, the vast majority of local government, they do their OCP and then it's a go forward. So they don't necessarily go back to look at all the inherited zoning that they have per property class and update it to their OCP. They do it on a continuous basis. But for me in my term, I've had huge surprises in terms of zoning to properties where you go, what the heck, what is happening here? And so our EASC is likely to get encouraged to redo the OCP. But now your presentation has made me think about maybe a better exercise would be to actually review to what extent, even with our 2010 OCP, whether the zones that exist in the possibilities of development or the non-possibilities of development align with what we've done with the existing zone. And then what you're saying is essentially this board could reclass a number of either classes or properties, and that's within our authority. Now, whether that would be viable with the public or with First Nation or the rest of it is a broader question. But to be honest, if we want to unlock some of the surprises and colonial and industrial legacies that we've inherited, it may be worth. I'll be brewing my thoughts for the next few months on this for sure. And the last question I have is, what if you're in play? So what if you had a building permit that's in process, but that triggers your realization that maybe the zone is incorrect? Could you intervene, or would it be some legal treachery in terms of in the process of permit applications that are getting approved or not, to actually look at the zoning as well?
Okay, well, there's a balancing of rights, right? And so as powerful as local government rules are, there's also protections for property owners. So even when property is being rezoned, for example, if somebody has submitted a building permit application and it's a complete application, and like I said, all the boxes are ticked to get their permit issued, and then they're at the point where they're will be able to establish a non-conforming use and then have the protections that the Local Government Act affords them. There's a division under Part 14 that deals with it that has quite a few sections, and they have to stay within those constraints, but as long as they're within those constraints, they'll be able to continue a non-conforming use. You can still change their zoning, in fact, that's how you would make them non-conforming, because if they're conforming right now. So what changing their zoning doesn't stop them from having the use. It just puts them into this more constrained framework that they would need to operate, which limits expansions and things like that when there's destruction, that sort of thing. So there's always, because there's some pretty extraordinary powers, right? There's very limited situations where you can withhold a building permit, right? One of the powers actually just came up recently, also out of a White Rock decision, where a property owner had gotten a development permit for a 12-story building. It complied with all the guidelines, they got it, but they hadn't actually started to build yet. They actually hadn't started to change to do the excavation or anything like that. And this was at the last, not the most previous election, but the election before that. The election happened, and the new set of officials came in and said, we don't want a 12-story building there. So they downzoned the land. But the process of downzoning, they first passed a resolution for staff to do, to prepare this bylaw. And then you go through the procedure that's involved there. So you have multiple readings, public hearing if it's not consistent with the OCP, or sometimes if it's controversial, you just have a public hearing anyway. The legislation recently changed on that. And then the consideration of final adoption. And through that process, the property owner has an ability to act upon their approved permits and get their building permit in and get that approved and so on. And if they had done so, they would have been protected that way, but they hadn't done so. And there was a debate, and what got resolved legally through the courts was whether the development permit itself gave them permission to get a building permit later, and the court found that it didn't. Right? There is an extraordinary section in 463 of the Local Government Act that says once council has passed a resolution to downzone, or the board has passed a resolution to downzone, and given notice to a property owner of that, that even before the downzoning is complete, they can pass a resolution to withhold a building permit application. And so that's one of the few times you can actually withhold a building permit if you've already started your resolution, even if the bylaw hasn't been approved. Now, it's a very strict framework under 463 of the Local Government Act, how that gets done. And I don't want to go into all the details, it's quite complicated, but even that framework, even that extraordinary power has a 7-day window that allows the property owner to get their building permit application in and not be subject to that extraordinary power. So there's this balancing of rights that has laid out, and it's the framework that the province has given local governments to work with it. Right.
Director Hardy?
Thanks. Thank you for your presentation today. It's very informative. As everyone, Chair Greaves had mentioned, there's a lot to take in and absorb. I guess an action item for me moving forward would be nice to be able to have you come in a couple more times throughout the next year, just to even provide more information to us. So that would just be one of my recommendations today, is to have you come in a little bit more regularly and share information with us. Thanks.
Thank you very much. Yeah, you probably have them come in every month and we still need to know stuff. But so what I'm taking away from this, of course, is the fact you keep using the word balancing act. And that's what we found too in some of our more contentious issues around this committee over the past term. But you talk about the difference between case law and actual statutes. Talk about the private property rights versus the public. So when it comes right down to it, it's not a hard and fast kind of, this is the way it is, because there's so much ambiance there. The nuance, the balance between every particular case comes into play, which is why, what does Shakespeare say about lawyers again? Anyway, so I think that the takeaway for me is that we have to be very, very careful and do rely on our legal counsel and do rely on our staff to help us navigate some of the more difficult pieces as we go forward in this term. But I would thank you very much on behalf of our committee, and certainly there's a lot here to digest over the next little while. I got about 4 pages of notes myself, and I can always watch the video if I need to. So thanks you very much for taking the time, and have a very safe drive back to Victoria. I think they're working on the Malahat as we speak. So have they ever stopped working on the Malahat? Sorry.
It's a different stretch every time. But I'm not going back tonight. I've got another one to do tomorrow.
Oh, good. Okay, that's great. Well,
Stay
do
well.
enjoy our Comox Valley and take in the sights. You can watch the snow removal in process here, and or maybe not so in the rural areas. But that being said, thank you very much. So I was remiss again in not asking for a motion on receipt. So moved and seconded. All in favor of the receipt? Thank you very much. And that moves us along at this blistering pace to, oh, pardon? Maybe we should take a quick recess. How about 5 minutes? Let everybody have a comfort break. Okay, so 5 minutes. Thank you. Okay, I call this meeting of the Electoral Area Services Committee back to order. And I believe Director Arbor has a motion.
Yeah, thanks. At the pleasure of the committee, Mr. Chair, I would like to see if we could go in camera regarding a legal matter at this time. So move to go in camera.
Seconded, okay. So we're going to convene in camera, so we have to ask you folks to leave the chambers if possible. And also those online will be back after a short in-camera session. We're just about live, are we?
Go ahead. Yep.
Ready to go?
Mhm.
Okay, I call this meeting back to order. We've made it all the way to item number 3. Orientation, planning and building services, and over to CAO for introductions.
Thank you very much, Chair and Directors, and your planning and development staff are here today to provide orientation, so I'll pass it over to them.
Good afternoon, through the CEO to the chair and the directors. Tom, Amanda and I are here today to provide you with an overview of the planning service, which includes functions 500 through to 503, planning GIS, land use by law enforcement, and planning policy, respectively. Function 500 and 50. Oh, sorry, Lisa wasn't paying attention. I'll just wait. It is, yes. I just wasn't following. There it is. And just back one more, Lisa, please. Yeah, great. Function 500 and 503 is responsible for providing land use planning and development services, which includes development applications, policy amendments, and then undertaking projects and initiatives that are either directed by the board or align with the board's strategic drivers in all 3 of the electoral areas, with the exception of Denman and Hornby Islands. And all matters and services concerning this service are considered by the Electoral Area Services Committee.
Can everybody hear me? Thank you. Lisa, can you just go back one slide, please? Thank you. So one of our daily tasks for planning staff is we spend a lot of time in answering questions and ensuring that their development proposals meet is consistent with the regional growth strategy, official community plan, and also ensure that their development is also consistent with the zone bylaw. Inquiries that we usually hear is, regards to how many dwelling units are we allowed to have on a property, setbacks and heights on buildings. Can I subdivide? How many lots can I subdivide? But also, if I'm developing on this lot, is there any development triggers that that I need to apply for additional applications? The CVRD has 4 advisory planning commission, each in electoral area A, B, and C. If an application that we receive is in electoral area A, that application will be directed to the electoral area A, APC, and B or C, depending on what application that is located. The regional district also has a regional agricultural advisory plan commission that they provide comments to staff, so we can include that comments into the staff report. These applications varies from subdivision on ALR land, ALR applications like non-farm use applications, but also our farmland DP applications. Next slide, Lisa. On this slide here, you can see the graph on the left and some points on the right. So work within the planning development is primarily undertaken by a general manager, manager of planning, manager of long-range planning and sustainability, 2 senior planners. One right now is a current plan, but their second position is currently vacant, but we're hoping to fill that spot soon. 3 planner twos, and 2 planning and policy analysts. As the graph shows, our majority of our applications are from our development permit areas, which is our environmental development permits, Heron and Eagles DPs. But also we do receive referrals from the Ministry of Transportation, which is subdivisions. So as you are aware, the regional district receive referrals from the Ministry of Transportation. We do not approve subdivisions. We also have seen an uptake in home occupations. I think this is part due to the COVID pandemic. People are wanting to work at home and starting business at home. So our zoning regulations permits home occupation within residential lots. In 2022, as of November 2022, we have received 115 applications. All this varies from development permits, DVPs, development variance permits, temporary use permits, ALR applications, and subdivisions. So we are actually a little bit busier than 2021, and I can see that this interest of applications will continue in 2023. Next slide, please, Lisa. I will pass this on to Amanda, who will speak about the bylaw compliance overview.
Thank you. So function 502 is within 500 in land use planning. That's our bylaw compliance component. So this department includes myself and 2 full-time bylaw enforcement officers and our bylaw coordinator. So bylaw staff is responsible for taking all written complaints received on land use violations and enforcement. So that includes anything from down to smaller situations, maybe setback of an accessory building, amount of derelict vehicles on a property, maybe a home occupation without a permit or beyond a scope, right up to our larger legal action files where we may employ assistance through a legal firm to see us through court action. So bylaw compliance is also responsible for ensuring development permits are applied for quite often retroactively as part of enforcement if someone's done some land alteration without the benefit of a permit, and enforcing activities in contravention of the zoning bylaw from those smaller ones to the larger legal action. So 502 supports all CBRD branches through enforcement measures. And I'll talk in some slides coming up, some separate functions as well for bylaw enforcement, but essentially our enforcement officers also support building enforcement, maybe enforcement through fire departments if they need it, parks, water enforcement through engineering, and then a legal dumping program for CSWM as well. Bylaw enforcement staff also works very closely with all of our other municipal partners, surrounding local governments and provincial partnerships, including Agricultural Land Commission enforcement, natural resource officers, and as always, our CMP.
I apologize for us going back and forth because this function has 4 functions. So we're co-sharing our presentation. So I apologize for that. Keeping the chair on the ball there. So this slide here, as you can see, it's a chart that shows projects that has been all initiated by the board. It also shows the strategic drivers that comes with each project. So for planning and development, we are wanting to amend the zoning bylaw that will look into the definition of automobile service stations. We are also going to be looking to a proposal to limit development of secondary dwelling units in the proposed sewer extension self-service area until such time that public services can be provided. We'll be working with the engineering department to draft a proposal to the committee in 2023. Unfortunately, as you can notice that chart is busy. One thing that I did leave out is that one of the direction from the board is to review our fees schedule for planning. We're hoping to present something to that in 2023. I will pass this on to Robin.
Perfect. Okay. As a part of implementing the coastal flood adaptation strategy, staff will be updating the floodplain bylaw. This will be to incorporate the results of the coastal floodplain mapping, as well as applying a risk-based approach to regulating development in the coastal floodplain. Dyke Road Park and Gartley Beach are examples of two demonstration projects that respond to climate change adaptation, as well as building coastal resiliency. And through these projects, staff will work to increase the awareness and the understanding of owning property in the coastal floodplain, increasing that understanding of what they can do to build their own resilience. For climate initiatives, just earlier this year, staff completed a GHG community emissions inventory, specifically for the electoral areas. And through this inventory, staff will use this as a resource to better understand the GHG emissions sources and trends. And this will inform planning and projects to reduce GHG emissions in the rural areas. The Food Hub project is building on the feasibility study that was completed in 2021, and staff are now exploring the viability of a food hub in the Comox Valley. And the agriculture plan is also in a process of being updated, and the plan will be coming forward with recommendations to the CVRD on how to grow and strengthen the food sector in the Comox Valley. And lastly, the Active Transportation Network Plan, although this was a regional plan, the implementation will be focusing on capital projects in the electoral areas. Staff are about to embark on a prioritization of the recommended projects that were included in the plan, and the goal is to identify the top 3 to 5 projects that should be undertaken first. Next slide, please, Lisa.
Thank you. So this slide is our financial overview for 2022. As you can see, the operating budget was approved in 2022. So I won't go through all the numbers, but you can see that on the power slide. For the capital budget, you can probably see a $20,000 budget there. That is related to GIS and with their programs. Their overall service is primarily funded by the requisition amounting to 82%. Application fees are not the significant component of the service, ranging from 2 to 3 for the overall revenue within the service. The residential tax rate is 0.273 per 1,000 of taxable assessed value as compared to 0.260 in 2021. Next slide, Lisa. So staff has seen an uptake on complex applications that are taking place in their settlement nodes. These applications are taking a lot of staff time in assessing these applications, but also it's involving other departments in our organization, engineering, parks, the fire service, and bylaw compliance. Their complex applications are in the settlement nodes, and you probably have heard the Yun Bay development, Upper Island development, and we just recently received an application in Saratoga at 400 Saratoga Beach development. Their proposal at a later date, I can give you a quick snapshot. So they're looking to build 432 lots in this area. Staff has also been speaking to other developers in the Saratoga area with other rezoning applications for the purpose of subdivision. These complex applications morph into other applications. If it's through a rezoning, most application that takes place for the rezoning application comes with development permits, variances on frontage. We also receive development permits that is all related to one big applications. So these applications do morph into other applications that also takes more staff's time. Staff has also seen an uptake, an increase in applications on hazardous areas. These hazardous areas consist of our steep slopes areas, but also proposals within a coast, which is with our floodplains. And these applications do take a lot of staff time, but also, takes a lot of staff time to educate the public in regards to these hazardous areas. Changes to the provincial regulations is resulting in an increase in local government responsibilities. These changes are putting staff in these spots where we are trying to educate the public, trying to understand the changes that are occurring. Such changes are related to the riparian area regulations, protection areas, where the province is requesting these assessments that needs to be reviewed by the province. These assessments that needs to be reviewed by the province is creating these delays for the owners to get the approvals. From my understanding, these assessments are taking up to 6 months for the province to review an application, then for staff to proceed with an application. But also changes to the agricultural land reserve. They are constantly changing their regulations, and as staff, we're trying to keep track of the changes and trying to educate the public with some more permissive uses on our land.
With recent project work on climate change and coastal flood risk, we're seeing an increased need for development and planning policies and bylaws to be looking towards climate adaptation and working towards building resiliency. This means there's a growing need to make sure our work is working towards this goal and incorporating a climate lens. And with this in mind, we're seeing a shift in approach towards risk-based planning as a best practice to mitigate and manage hazards. For example, our coastal flood adaptation strategy, this took a risk-based approach. And so in a nutshell, it involved digging into the technical hazard, but then also understanding the implications that are associated with that hazard. So as a result, we are starting to see the shift in risk-based approaches when looking at regulating development in hazardous areas. There's also a growing need for partnerships and collaboration in our project work. So much of our recent work has involved multiple partners, and this has led to increased efficiencies with multiple disciplinaries and opportunities for grant funding. And this has been really critical in our work with Green Shores and the update to the Ag Plan. And through a food security lens, we are seeing a need to strengthen the agriculture sector and encourage succession planning in order to retain and increase local production. Technology and innovation is also central to maximizing production, decreasing costs, and also responding to climate change. And with that, we'll conclude our presentation, and we are open to any questions.
Well, thank you very much. Any questions from directors? Director Arbor?
Yeah, thanks. That was actually pretty quick for one of our biggest functions. Because we received an email about our APCs with I think a deadline of this week, sometime December 9th, I think we were given to answer whether we were going to have an APC or not. What would be the process if I want to make change to the terms of reference to my APC? The discussion I had with some of the members was that there may be an appetite to spend less time on minor variance application. And we know with building permits and the rest of that, we've really fallen behind. So there was also a thought it might save a step in the process. And have the APC, especially for Area A, with all the changes that are on the horizons, to have it more focused on the bigger topics that the community is concerned around, on the planning department, especially around Union Bay, Royston. So is there an opportunity, what would be the appropriate time to look at those terms of reference if we wanted to take out the minor development variance from those meetings, which I realize might eliminate a lot of meetings, and then focus that advisory panel on the more long-range planning questions?
Through the CEO to the chair to Director Arbor. That's a great question. The APC, it's really up to the directors themselves to decide what applications they want to be presented to the committee. We can work with you to figure out what applications you see. As you mentioned, if you don't want to see this minor DVPs, the variance applications, then staff can remove that off the any upcoming agenda for the purpose to speed up the process. But you're right. One thing about the APC process is the committee only meets once a month. So if we do miss that meeting, it's delayed for 30 days until the next APC. So we have heard that through people who are applying for their applications.
So what I'm thinking, so maybe that's the direction I'll give now, is for my EPC would be to maybe not meet once a month and meets once every 2 or 3 months, but with meatier topics. So when there's different things that happen, say with Union Bay Estates or with our active transportation network, I think that's the place where community members ask questions around the future of their overall community, and not so much about what's happening necessarily with the fence. So so if that's sufficient for me to ask for that adjustment in the terms of reference for my APC, I'd like to propose that.
Well, I must say that Area C APC seems to have enough to keep on its plate. We've got some big items coming up too, but they may be special discussions at the appropriate time. And of course, it's also a matter of just testing the waters, I think, every month. It's really good just to the informal part of it, just getting a bit of a read of what's going on on the ground out in your community. Is there any other questions around from planning? I guess the big question is, so what are we going to do about speeding up building inspections and cutting red tape on that? And I guess that'll be coming forward later this spring. Is that correct? Yeah, because I just coming in today, I just passed a very disgruntled plumber who wonders why it's taken him 4 months to do stuff he used to do, like, oh, take this up and pay at the front. Now it's maybe next month. So anyway, there is a, as you probably know, there is an impetus behind this because people in the middle of construction, it's costing tens of thousands of dollars every time we drag our feet. So that's my 2 bits worth. Anyway, nothing else on that one. Thank you very much. And we're going to ask again for a vote on receipt of that. Okay, all in favor? Yes. Carried. Okay, now we're on to the Electoral Area A Commercial Industrial Form and Character Development Permit 15A21 Holiday Road. Did I miss one? Sorry. We got one more. Oh, I didn't think I'm gonna give Amanda a chance here. Sorry. Press your little button there.
Which one do you have up first, Lisa? I'm easy. Bain Sound, A, B, and C. Yeah. Through the CAO and the chair. So the next set of slides and presentation is on function 291, which is bylaw enforcement for Bain Sound portion of Area A only, Area B and Area C. This was a newly formed service. Some of the directors may recall as of last year in 2021, where we combined existing services of animal control, noise, an unsightly premise, and fireworks into a separate all-inclusive bylaw function for those areas. So the service also provides water enforcement, parks patrols, and enforcement, as well as enforcement for illegal dumping for those areas. So bylaw staff, sorry, next slide, Lisa. Bylaw staff respond and investigate to complaints received with the goal of voluntary compliance first before we increase enforcement measures. So voluntary compliance, timelines before we would get into issuing our various levels of ticketing, provincial court action, and then ultimately